Hi. So, whenever you are visiting a hospital for an operation, and invariably, doctors or the hospital authorities take a consent form from you. And if you try to read those terms and conditions, invariably they will be in the favor of hospital or the doctor. But today I am going to share with you that even though the consent form or the terms and conditions in the consent form are in favor of the doctor or the hospital, the medical negligence will be fastened, will be saddled to the doctor who is conducting the operation, or the team of the doctors who are conducting the operation and the hospital. I'll explain why. The one ground is that it is against the principles of natural justice, and the second ground is that the hospital or the doctor is in a dominating position. So, whosoever is in a dominating position in a contract has to have moderate terms and conditions in their favor. In addition to that, it is a printed form. When it is a printed form, the patient doesn't have chance to bargain. The bargaining power of the patient is very less. If he starts bargaining, doctors will reject the operation, but which is a necessity and emergency to the patient. He signs in silence. In those circumstances, the patient must always remember that law is on his side at that point of time, because the doctor and the hospital are in the dominating position. They are in a position to use undue influence in accordance with the Contract Act. So, whosoever is in the dominating position, and when taking a printed contract or entering a printed contract, requesting the patient to sign on the printed contract, must have moderate terms and conditions in their favor and serious terms and conditions in favor of the patient. If such is not the case, law will attribute malfeits to the doctor and the hospital because they took advantage being in a dominant position. Hope I'm clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.